Hello, this is Ziad Youssef, and if you've been arrested for a DUI, then you need to get prepared because things are going to move fast. For example, at your first hearing called an arraignment, the judge is going to expect you to know three things: the definition of the crime, the rights that you have while the case is pending, and the possible consequences. All of those are things that we're going to explain to you, starting with the definition of a DUI. The state has to prove that you're guilty beyond a reasonable doubt, and that means they have to prove that you were driving and within 2 hours of driving were over a .08, or that you were driving and were affected by alcohol or drugs while you were driving. And your rights at arraignment include to be presumed innocent until the state proves you guilty beyond a reasonable doubt. So we're going to call into question each part of that case and enter a not guilty plea for you at arraignment, because if you're found guilty, there are some mandatory consequences that you need to be aware of. Mandatory fines. There's also some mandatory jail. You could face a mandatory minimum license suspension, a requirement to have an ignition interlock device in your car, and up to 5 years of probation on a DUI. These things can get overwhelming, so it's great to have a supporting staff all throughout the process, and to have a great attorney looking at the legal issues to make sure that the officer didn't miss anything. Because if they did, we're going to leverage those legal issues for you to give you the best possible chance at getting a great outcome. Sometimes those outcomes include a reduction to reckless driving or negligent driving, both of which don't require that you have an ignition interlock device in your car, and both come with a reduced probation sentence. Neither one of those has any minimum jail either. So if you need help, please reach out 360-734-0908.